the committee or task force, and I have no oral report other than to say that I'm very pleased with the work of the committee. I'm very pleased with the report that's been generated. I want to again extend my sincere thanks for the work that the committee members have done. I'm very pleased that Professor Tara Sklar from the University of Arizona, who was one of the experts who consulted with us, is here today. Welcome and thank you for attending. The other expert was David Studdert, a professor of medicine and law at Stanford. Both of those people were very helpful, and again, on behalf of the task force, I want to thank each of them for their contributions to this effort and to this final product. And finally, I want to say that I think our own inimitable Dag McLeod has done a great job in almost single-handedly shaping the way that this task force proceeded. He did so much in terms of coordinating this, finding the experts, the consulting, moving this process forward, researching as he went, and then preparing the first draft of the report itself. A number of people had inputs into the final report, but frankly, the substance of it, in my view, didn't change, and that's a real compliment to Dag, not only for his work on the actual writing of the report, but throughout. So, Dag, thank you very much. You've done a really terrific job.
Thank you, Alan. That's very kind.
There is nothing on the consent agenda, so we will move to the action. But first, I would like to see if any of the members who are attending from the public have any comments they would like to make to this committee. There are two ways to do that. If you're attending by Zoom, there should be a little sign at the bottom of your screen, if you scroll down, that would raise your hand, and we would be able to see that. And I don't see anybody at this point yet who's so identified themselves, but please do if you are interested. And if you are calling in, what is it, *7?
*9.
*9. Press *9, and we will receive the electronic signal that you are trying to call in as well. So, Ellen, if you will, please let me know if you see any indication from any of the public members that they would like to be heard.
Yes, I will.
The public, that they'd like to be heard.
I show no hands at this time, so.
All right, well then do let me know if anybody does indicate an interest as we're speaking. But let us now go to item 3A, the review and approval of the 2020 report. And Dag, I turn it over to you.
Right, well, thank you very much, Alan, and thank you again for your kind words about the report. I have a presentation. I'm going to try to limit it to, it's about 10 slides, and I'm going to try to move through it relatively quickly so that we can reserve the balance of the time for conversation. I guess two thoughts about your kind words. One is that I have been very fortunate in having met Professor Sklar, who has really helped me understand a lot of the stuff that's going on in this field. The other is this was one of those moments where, you know, many times in your career you question why you took the time to go to graduate school. Those few times when I thought, no, it's a good thing I went to graduate school, because to a large extent I was summarizing the findings of other people who've done work in this field. So what I've attempted to do here is take the good thinking that's been done by people like Professor Sklar and Professor Studdert, and then also some of the literature that they pointed me to, and bring it together into a report. So summarizing the Governance of Public Interest Task Force charge, which I think you all know, and which will be provided as Appendix A. I think that the draft that you had did not yet have the actual text of Business and Professions Code 001.2B, but this is the charge of the governance task force. We've talked a little bit about this as well, and cover it briefly in the report as well. The fact that the previous reports of the governance task force were very inward focused and written at a time during which the state bar was in a great deal of turmoil, crisis even related to ineffective management of the discipline system. And as a result, I think appropriately, those reports were very much focused on the organizational structure of the bar, the size, structure, and composition of the Board of Trustees, the hybrid structure of the bar, proliferation of activities, confused reporting relationships, and proliferation of committees, commissions, and boards. And as trustees, you guys have all been living a fair amount of that work. Some of the Appendix I work continues to come before the Board of Trustees. You'll see an item or two tomorrow related to follow-up from the Appendix I work. So that work has really continued on. It has not been put to rest, so to speak. And I think for that reason, when the Governance of the Public Interest Task Force first met in 2019 and was looking for direction, the idea was that we would pivot from the inward focus of previous reports and look on the regulatory functions of the bar rather than its organizational structure. It was discussed early on to look at risk prevention, seeking a proactive data-driven approach to regulation. And this was still within the 2019 timeframe that staff was charged with investigating other jurisdictions, other professions where risk-based regulation is being used. So in the 2020 meetings, we had an excellent orientation to risk-based regulation, along with a overview of what's being done in the medical profession by Professor Studdert. That was in February, and then in March, just before the world turned upside down, we had the presentation in Los Angeles by Professor Sklar. I do note in the report that coming out of the March meeting in Los Angeles, the suggestion was made that we also take another comparative perspective related to the private sector and look at the way in which malpractice insurance, how firms that sell malpractice insurance evaluate risk and what factors they take into consideration, and how we might learn from that, as well as how law firms evaluate their own risk and take that into consideration. And that stream of work was not developed. I'm gonna blame the coronavirus. Other things became more pressing, such as figuring out how to organize Zoom meetings. So it's unfortunate we weren't able to develop that strand, but I wanted to note that to you verbally in this presentation. It is in the report that was discussed in March, and something that we would like to get back to. As I move to the next slide, I did want to say one thing. When I've got a screen share on, I don't see anybody, so please don't hesitate to speak up if you've attempted to get my attention by raising a hand or making some sort of visual gesture using Zoom. So the report that has been drafted and that we are proposing to submit to the Supreme Court, the legislature, and the governor coming out of the 2020 Governance of Public Interest Task Force focuses on risk-based regulation. It begins by talking about what risk-based regulation is, which is what this slide summarizes, and it relates to using an analytic focus that looks at data to understand the regulated population, focuses on caseload in addition to cases. And the focus on caseload is intended to uncover trends and patterns of risk related to the regulated population that don't emerge when you're simply looking at individual cases. The policy implications for taking that analytic focus is that the regulator then has the opportunity to target the application of rules and regulations and standards. That targeting, I think, implies some prioritization. If you're going to target, then obviously there are things that are further out of the target than further out to the edges of the target than toward the middle of the target. So the policy implication also involves prioritization of issues in the regulatory field that present the greatest risk, and also a preventative approach, seeking to provide education, information, and support for attorneys who are at risk of being disciplined, at risk for engaging in misconduct. The report goes into a somewhat more detail regarding both of the research in medicine and the research in law. There's a separate section for each of these that reviews the findings related to factors that predict complaints and predict misconduct, how they're measured. The findings are very similar across the fields in that men are more likely to be found to have engaged in misconduct or to have received complaints than are women. Older attorneys are more likely to be at risk than are younger attorneys. Firm size appears to be a factor. Smaller firms and solo practitioners are more at risk than larger firms, than practitioners who are in larger firms. Among the strongest predictors of misconduct in either of the fields are prior complaints and prior discipline. In the medical literature profession, and in particular because the medical literature, some of it looks at complaints and misconduct, allegations of misconduct and malpractice claims that are filed across a range of different professions within the medical field. The literature is able to look at the way in which, say, pharmacists are at greater risk than nurses. So there are distinctions within the medical literature that we can't really get at in the legal research. There are specialties also, obstetrics and gynecology, for example, internal medicine, that have a higher risk within the medical field. We have anecdotal support for the notion that specialty matters. We've certainly had conversations with attorneys in the Office of the Chief Trial Counsel who will tell you that criminal law is probably a field that puts an attorney at greater risk for receiving complaints, if not misconduct, actual discipline. Family law, also a field that appears to be a higher risk field to be practicing in. But I put question marks under the section on law because it is just anecdotal information at this point. Another factor in the literature on the law that puts an attorney at greater risk is having trust account authority. And that obviously doesn't apply to the medical field, so I left that as not applicable there. I've got a couple closing slides that I hope they're intended to provoke some conversation. And one of them has to do with the follow-up research that was conducted by Professor Sklar and her colleagues. And it was qualitative research that looked at some especially complaint prone and discipline prone attorneys. And one of the things that I thought was really interesting about this work was that it showed that personal problems were not at all easily segregated from professional problems. In many cases, these attorneys' professional problems originated in crises that occurred in their private lives. They could be financial crises, relationship breakdown, mental health problems, and these personal problems ended up becoming professional problems. And to my mind, what that raises in part, and is something that we might want to talk about, is the question of a supportive role for the regulator. And I put together a little schematic here. And I think that this is especially relevant in light of the way that the State Bar has been reorienting itself toward a clearer regulatory function in the last number of years since the separation from CLA. But I tried to lay this out on a spectrum to suggest that it's entirely appropriate that the State Bar is no longer engaged in advocacy. That's a matter of professional advancement. That's what the California Lawyers Association is supposed to do. It's partly why we separated the State Bar from the sections. It's also, I think, well understood and easy to wrap our heads around the idea that, you know, we're about public protection. That's the function that the State Bar performs, and to a large extent that involves enforcement. But I created that little green space in the middle there. This is supposed to be sort of a rectangular Venn diagram. And my sense is that really that's probably a shared space for both the California Lawyers Association and the State Bar, where public protection really is aligned with the support of attorneys, in particular attorneys who may be facing problems or may need additional education, may need to be nudged in some way or another to avoid falling into some sort of perhaps predictable trap related to how they manage their affairs. The other issue that I wanted to put up that is actually in the report, this is one of the figures in the report. This came from Professor Studdard in his discussion of prediction models, and the discussion in the report talks about the fact that any model will have a margin of error. There are no perfect prediction models out there, and the challenge for operationalizing risk-based regulation is that you're going to get hits. You're going to get a prediction on individuals who ultimately won't engage in misconduct. And so the question is, what is an appropriate intervention given that you know you have a model that will always have some error built into it, in particular false positives. So I thought that this was a nice illustration that Professor Studdard provided, which is why I stole it and adapted it to my own purposes. But the idea here is simply that the supportive sorts of actions on the left-hand side of the horizontal axis there are, I think, the more appropriate types of interventions that the State Bar would want to be looking into, where the State Bar can proactively notify, it can conduct outreach. Even education, I think, even though that falls over to the right-hand side, I think it's something I need to talk to Professor Studdard about to understand why he sees that more toward the sanction side. But I think it's when you get toward the far right side of that horizontal axis that it's trickier to figure out how you would use a prediction model to conduct risk-based regulation if it were involving sanctions. So the next steps that are envisioned and recommended in this report are for staff to return to the board at its January 2021 strategic planning session with a detailed plan for moving forward. And the steps that we would take and that are recommended in this report prior to the January 2021 planning session would include evaluating existing databases. There are a number of areas that I can go into each one of these. I don't want to though just be talking at you. So I won't go into detail on each of these, but we can evaluate existing data that we have. I think that there's some areas, some opportunities. We can conduct a qualitative review of case files to identify additional data that we think might be available and needs to be structured properly to use. I think we can scrutinize complaining witness data more closely. I think this is an unexplored area within our research at this point to understand better what the complaint categories are, how they relate to different types of practices, and whether there are not expectation management things that might be done in particular practices to get clear with clients of attorneys what they really can reasonably expect and what type of behavior is actionable and constitutes misconduct and what does not. And then finally, development of plans for some small scale pilot testing based on the findings from the data analysis. So that, in a nutshell, is the report. I tried to follow the executive summary outline, which I put together last night. The thing that I missed on that executive summary was the 2021 strategic planning session, but that would be sort of, I think the big target would be to get to the strategic planning session with a more fleshed out body of recommendations. I invited Professor Sklar, and I hope I'm not putting you on the spot, but I know that she has a much deeper knowledge of this work, and since I've been sort of skimming over the surface of it, I would welcome her thoughts on any more particular specific issues that might be addressed moving forward.
Sure. I mean, I thought that was just a terrific summary and suggestions to consider for next steps. I thought you did a very nice job showing where risk-based regulation really is helping both the legal and medical professions in terms of really targeting who are the problem offenders in the different fields. And it's so interesting that they take very different approaches. Medicine often takes a much more supportive hand-holding approach, it seems like, from the beginning, whereas law has a tendency not to go in that direction. So that's one way that they diverge and I think learn from each other. So the only thing I would just say right off the bat, and it came off, I think, in one of your third or fourth slides, is that, for example, the area of law, you said anecdotally we've heard it's criminal or maybe family or we don't really know. And so there was a question mark by it. And I think that's sort of the number one step here is just to get a better sense of your intake processes, your data, how the complaints are clustering in certain areas to help you better target your interventions. And then from there, you can start to scale out what some pilot projects could look like in terms of, you don't want to have repeat offenders. You don't want careers of misconduct. So how to get there is I think, what you're trying to do with the ultimate goal with risk-based regulation. So you're trying to get just a sense of who these complaining witnesses are, really categorize them and profile them, and then with that, the complaint data to target the lawyers. And our experience in Australia, it ended up being only 4% of our entire registered lawyers in the state were causing such havoc. And then we could really say, oh, it's this area of law, it's these firm practices sizes. And you know, that's not, as we discussed at our meeting, there could be some bias there in terms of malpractice could be happening in other larger firms and we just don't hear about it because it settles for different reasons. But in this case, you have a genuine constituent that's complaining, you have data you can track, and I think it's a way just to get a handle on where to start. So those are my few thoughts, and that I think you did a really nice job outlining all the issues and then potentially where you can go with it.
Thank you.
Yeah, sure. I'm here to help answer any questions, whatever might be useful.
Okay, Dag, anything else before we go into discussion? And
That was all I had set for the presentation.
okay, then I'll throw it open to the members. Does anybody have any questions, thoughts, comments, or suggestions? Ruben?
Start. I don't know if you can hear the
Yeah.
leaf in my neighborhood. If so, I apologize. I'll move inside. But I just wanted to echo Alan's thanks to Dag and Professor Sklar and everyone else who put some serious thought and time into this aspect of what it is that we do. So often we hear about the justice gap and all of our other statutory duties, but the issues as you presented them here, I think is an important thing for us to remember as policymakers. Certainly no easy answers in the field, but the questions that you've posed, I think, are going to help us get there over the longer term. I look forward to seeing what happens in January for sure. Nothing specific other than it's super interesting and certainly a lot of food for thought. So thank you.
Thanks, Ruben. Anybody else? Okay, well, yeah, Jose? No?
Thanks, Alan. I just want to echo what you and Ruben have pointed out, which is I think the report is very well done. I think the research and the conversations we've been able to be part of and the opportunity to look at these issues going forward is actually exciting. I think this is exactly what we should be looking at. And this is the kind of improvements I think we can bring to the industry. So let's travel firmly and strongly in this direction and see what we can learn and see what we can bring to the folks in California.
Okay, great. Thank you. Thanks, Jose. All right, well, let me break this into two parts then. First of all, the report itself. Does anybody have any suggestions or comments on the report, or are we comfortable with it being submitted as presented to you in version 2, which Dag circulated a few days ago? And Dag, I don't think we need to necessarily take a vote. We seem to have a consensus. If you feel more comfortable with the vote, we can certainly take it, but it seems like everyone's on board.
That sounds great.
Okay.
I'm excited not to be going back into copy edit. So that's a
All right.
great sense of relief.
Yeah.
But yeah.
All right, based on what I'm seeing and not hearing, I believe that we have a consensus of this group that the report should be submitted as presented. All right, then the second question is, in terms of the recommended further steps, culminating with presentation to the board at its January 2021 strategic planning session, does anyone have any objection to following those steps as outlined by Dag?
Yeah.
Alan, this is Ruben. Not an objection at all, but certainly maybe something to think about in terms of a focus. In particular, Dag, that your rectangular Venn diagram where we're on one side and the CLA is on the other, and that support overlap caught my attention, and I think might be a useful area or a useful springboard for some meaningful programs or cooperation between us and the CLA, and even just on our own end as to, okay, there's a support function. Where does that really, how does that really play into our core mission? And speaking as one board member, I think certainly it should. I guess it's going to be a question of to what degree and how do we integrate it into the rest of our functions. But it was very intriguing to me to see it. I'm a visual person, so to see that laid out that way was, I thought, very good.
Thank you.
Let me just piggyback on that comment from Ruben. During this pandemic, we keep getting emails from CLA, right, with different CLEs, and it's usually on some substantive legal topic. For example, business interruption, for breach of contract claims. It's just sort of like legal issues that are arising because of the pandemic. But what we haven't been seeing, and that I think represents a really great opportunity in that sort of state bar working together with CLA, are things like, what are the risks posed with respect to the legal practice right now, with respect to the practice of law, and what are ways to mitigate it? And so, for example, our firm gets those types of emails from our malpractice carrier, but how great would it be if the state bar could send those out to all members to say, hey, during this time, here are ways in which risks can arise. And so, for example, it could be, because business is slow, you could feel more incentive to take on a client that in normal times you'd feel kind of weird about, right? Like your alarm bells would be going off that maybe this isn't such a great client. It's not, it put me in a sort of bad ethical position. And those are risks that can arise. And how great would it be if you could flag that for CLA membership, for State Bar, through various emails, and to say, here's how to mitigate it. And that would be a really proactive way of reducing problems for the public.
So I don't want to put Professor Sklar on the spot again, but we did have a side conversation in which she had flagged something almost identical to what you're talking about, where she was saying very specifically, well, I'll turn it to Professor Sklar.
No, I'm just laughing because I've had like deja vu to the March meeting where Eileen and I were like, yeah, could you do that in the hospital?
Yeah.
Again, to do another parallel with the health profession, and not, but also with my work in Australia. So I keep in touch with them quite a bit through the pandemic because I'm just sort of curious, how America's approach the pandemic differs from how other countries have, and what are they doing in Australia? How is it working down there? And so some of them are in the healthcare profession, and others are with the Victoria Bar. And both groups are doing different things. And for the health professions, they've created a resource that they've based off Maslow's hierarchy of needs. And they're really approaching it like a health profession well-being. I mean, as we know, that's very scary. It's a different conversation than
We lost your audio.
Oh, I'm so sorry.
There you go.
Okay,
You're
sorry. I'm not sure where it cut off. The health profession organization in Australia organized a body of work designed around Maslow's hierarchy of needs. And it was a way for healthcare providers to help avoid burnout, how to manage, mitigate risk. And that's a very famous theory that's well recognized. Just are they really getting their basic needs met? And it's offering that support. So it might be a little, I told Dag, I use the word Pollyanna. It might not be what you are looking for, but I certainly think some of the resources are valuable, and it's definitely a recognized theory in management literature. And then the bar in Victoria is very concerned with lawyer well-being, and we've identified many times financial distress as a risk factor for misconduct. So they're looking at ways to help protect that, whether maybe it's minimizing bar fees, maybe it's support for certain CLEs, any way that you could be more proactive, I think would be really appreciated and recognized.
Yeah, I think this idea that the pandemic is invariably going to create personal crises for some attorneys, and that those personal crises could result in professional problems. If there's any way at all that the state bar could operationalize that a little more specifically and provide some support, it could be an interesting thing to do. I don't know exactly what it looks like still.
Well, I think that this is Debbie. I think for some of the solo practitioners to have the bar sort of reach out to them when there's crises going on, like the pandemic, I think would be helpful to them. So because they're already feeling alone because they are a solo practitioner, so to sort of have that little bit of a bridge to the bar, that there's somebody who they can sort of turn to a little bit in terms of what best practices they can use, being a solo practitioner, being on their own in a pandemic. I think would be helpful. I like the whole idea of the wellness. I think that's important.
Yeah, I agree with that. I think the wellness, I think even beyond solo practitioners, I think just like the reminder emails that I've been getting from our carrier and from our firm's general counsel are things like, now is the time when you could be missing deadlines, right? It's really easy to blow a deadline when you're working at home in an environment that you're not used to, and when courts are closed, and that changes all of our briefing dates, and there's a lot of disruption, and it's easy to get something wrong. I think there's also a good reminder that now that we're working in a different environment, you need to think about protecting client confidences in a different way, right? Like you used to be able to be in your law firm office with your door closed, and now you're working in an environment where perhaps there's other people around you, other family members who are listening in, you've got confidential documents that you're leaving around your house, and things are different. And I think it's a good reminder. I could totally see something like that coming from the state bar, perhaps together with CLA, saying like, this is a new environment. Here's some things that you have to, double down on, is remembering your obligation to keep client confidences, right? There could just be a sort of like alert about that. And I think those are sort of proactive reminders that I think would be really well received. And the deadlines thing I know is for sure an issue.
And that stuff, it serves a dual purpose of the substantive reminder to people like, hey, don't forget this. And also at the same time makes them feel like someone's watching out for them. They're feeling cared for.
Yeah.
And
That's sort of that sort of high touch kind of approach. Yeah.
I think that's really important. And Ruben touched on something that I had thought of too. When we did see that rectangular Venn diagram, have you reached out to CLA on any of this yet, or is that in the future?
I have not
Yeah.
spoken to them
Okay.
about this.
I would bet that there would be a fair amount of receptivity to working in that center box. I also am. I'm definitely in favor, not only for a lot of good reasons, for this proactive approach to, reminding attorneys, warning attorneys, assisting attorneys, and so forth. I think there's a real role for that, and it has a direct public protection nexus. I also hope that we do not become the agency like the IRS that, the only news that we ever bring is bad news. I think there's a bigger role for us than that. So, okay, I don't want to drag this on any longer than necessary, but I also don't want to cut off any other thoughts or suggestions. This was a great time. We do have this as an agenda item tomorrow on the Board of Trustees agenda, so we can we certainly inform the rest of our board members at that time about some of our thinking and what we've learned. But just for the purposes of this working group, does anyone have any other thoughts that we can leave with DAG or questions they might have for Professor Sklar? Yeah, Ruben?
I know that a couple of the CLA board members have been in attendance at our recent board meetings. I'm thinking of LA in particular. It might be worth a formal outreach, Alan, either from you or from DAG in advance of the January meeting on this particular issue, to say to them, we'd love to have a couple of representatives or one representative from CLA who might be particularly interested in these issues to be present, and we'd welcome your thoughts and your feedback. Something, just a special invitation for them to be part of the conversation.
Absolutely, great idea, and we'll do that for sure. Anyone else? Okay, then I am going to proceed on the assumption that we have a consensus that as to the second part of this question, we agree to forward DAG suggestions to the board. And with that, unless I see any violent waving of hands or moves to the microphone to cut me off, I think that's it. All right, again, we have no closed session and we will stand adjournment. And again, I want to thank everybody very much. I think we've come a long way in a very new and exciting area, an innovative area. So thank you. Thanks all.
Yep,
Thank you all.
guys.
Thank you.
Bye-bye.
Bye.
Take care, everyone. Thank you.
Bye, Professor Sklar. Oh, DAG?
Yes.
Um,
Let's 2 seconds. Let's make this a private meeting. Ellen, can you remove the attendees from the?
yeah.
Yeah. We're
We're
still
gonna lose
sort
Sean.
of in public. Do you want to have Sean in the meeting too?
Yeah, can we do that?
I think we
Yep,
can.
I'm here. I'm just by audio.
Yeah.
Let me,
But if I hit attendees, will I lose Sean?
I think that Ellen, I don't think that you have the awesome authority that Ellen Louie has.
Okay,
And let me give her a quick
I'm
email.
right here.
she's on.
Oh, terrific. Can you vacate the attendees from the attendee section? Can you just kick them? No offense, attendees. They're actually, I think there's Linda. It's there, and there she goes. Okay, and we're almost. Okay, it's just us now and Ellen.
Okay. So what I wanted to ask you was, or mention to you is this. It's possible that we'll have